Supreme Court Justice Salmon Chase. He was born in Cornish, New Hampshire on January 13th, 1808. He had a lot of siblings and he was the ninth of 11 kids. His father died when he was 8 in 1817. He was sent to live in Ohio with his uncle Philander Chase, who was an Episcopalian bishop. He went to Cincinnati College in 1822 and later Dartmouth College, where he graduated from in 1826. He went to Washington, D.C., where he was a teacher before studying law under U.S. Attorney General William Wirt. He moved to Cincinnati, Ohio in 1830 and began practicing law. During that time, he established his legal reputation by publishing a multi-volume history of Ohio laws. In 1834, he married Catherine Garnis until she died in 1835. He then married Eliza Smith in 1839 and had 3 kids with her before she died in 1845. He finally married his third wife, Sarah Bella Dunlap, until she died in 1852. He defended James G. Birney in front of the Supreme Court in 1837 after he was charged with harboring an escaped slave. And he defended another abolitionist, John Van Zandt, also in front of the Supreme Court in 1847. His defense of abolitionists and escaped slaves earned him the name Attorney General for Escaped Slaves. Chase first entered politics in 1840 when he served on the Cincinnati City Council. He was an advocate for ending slavery and led the Abolitionist Liberty Party. Chase coined the party's famous motto, "Free soil, free labor, and free men." He later got a seat in the Senate on the Free Soil Party ticket, but he later identified as an independent Democrat. He opposed the Compromise of 1850, which allowed for new fugitive slave laws, and opposed the Kansas-Nebraska Act, which allowed the states to choose to allow slavery instead of stopping the practice. After he left the Senate, he aligned with the new Republican Party and became governor of Ohio on the Republican ticket. Chase attempted to run for president in 1860, but lost the Republican nomination to Lincoln. He was elected into the Senate in 1861, but left because Lincoln appointed him as Secretary of Treasury. He was Lincoln's United States Secretary of Treasury from 1861 to 1864. He played a major role in having "In God We Trust" on our money. He created the National Banking Act, which became law in February of 1863, which created a national bank and a single currency, which allowed the government to issue millions of dollars in bonds to fund the Civil War. Chase was bitter to having lost the nomination for president to Lincoln and threatened Lincoln 3 times that he would resign in order to force him into political appointments. And on the 4th time, Lincoln accepted his resignation and Chase stepped down later that month. Lincoln saw Chase's talent for law, and he appointed him as Chief Justice on the Supreme Court in 1864. He saw over many cases of the Reconstruction era and supervised over the impeachment trial of Andrew Johnson, which ruled the president was within his rights to enforce Reconstruction measures in the South. He saw over many important cases, and one of them was the case of Hepburn versus Griswold. Chase ruled that the legal tender acts, which were instituted during his time as Secretary of the Treasury, were unconstitutional. He made multiple attempts to run for president while on the Supreme Court until his death in 1873 at 65, but he failed to earn the Democratic nomination and the Liberal Republican candidate nomination. When the Chase Bank first opened in 1877, it was named in Chase's honor, and Salmon Chase was on the largest United States bill issued for public use, which was worth $10,000.
Our Supreme Court case is Brown versus the Board of Education. Thurgood Marshall, the head of the NAACP Legal Defense and Educational Fund, served as chief attorney for the plaintiffs. He would later be appointed as the first black Supreme Court justice by President Lyndon B. Johnson. Even though the name Brown versus the Board of Education was given to 5 separate cases, they all concerned the same issue of segregation in public schools. Oliver Brown filed a class action suit against the Board of Education of Topeka, Kansas in 1951, after his daughter Linda Brown was denied entrance to Topeka's all-white elementary schools. Brown claimed that schools for black children were not equal to the white schools, and that segregation violated the so-called Equal Protection Clause of the 14th Amendment, which holds that no state can deny to any person within its jurisdiction the equal protection of the laws. The district court ruled in favor of the Board of Education, citing the separate but equal precedent established by the 1896 Supreme Court case Plessy v. Ferguson. The Brown case was appealed to the United States Supreme Court. The Supreme Court first heard arguments for the case in December of 1952. Because of resistance from southern states, no decision was reached. At first, the justices were divided on the conclusion. Chief Justice Fred Vinson sided with the Plessy verdict and believed that separate but equal should stand. But before the case was heard, he passed away and Earl Warren replaced him as Chief Justice. In May 17, 1954, it unanimously ruled segregation unconstitutional. The court reasoned that the segregation of public education based on race instilled a sense of inferiority that had a hugely detrimental effect on the education and personal growth of African American children, and segregation violated the Equal Protection Clause of the 14th Amendment. Despite it resulting in a unanimous decision, the chances seemed slim in success for the plaintiffs at first. It had begun as 5 separate lawsuits filed on behalf of black elementary school students who attended legally segregated schools. All 5 had resulted in defeat in district courts, and none of the 5 lower courts did away with laws mandating segregated schools.